Thank you. Would you ask Mr. Menzies to come back in, please? All right, Ms. Menzies.
Yes, thank you.
Ready to carry on? Yes, when you're ready, Ms. Crane.
Yes, thank you. Yes, Ms. Menzies. In a moment, I'm going to start exploring with you some of the main conclusions that you've reached in your report. But just before I do, can you just help us? What is the usual qualification route that people follow to become a building control officer? What type of qualification would they routinely undertake?
These days, it would be usually a degree in building surveying. Or following the route right the way through to becoming a member of CABE, Chartered Association of Building Engineers, or you can actually take a degree in building control.
Okay, good. Thank you. So, your main conclusions, first of all, about RBKC's Building Control Department. If we can go on page 9 of your report, paragraph 32. And we can see there that you say, disclosures to date indicate that the Building Control Department lacked a strategic policy to support the legal obligations of RBKC to achieve and enforce compliance with the Building Act 1984 and the building regulations. Can you just help us, when you say lacked a strategic policy to support those legal obligations, what exactly do you mean by that?
I've not seen anything in the disclosures that suggests to me that there was a policy that staff were required to abide by, whereby decisions were made within the statutory time limit, that certain policies were followed to ensure that the requirements of the building regulations as regards time limits and getting decisions out and achieving compliance for completion certificates were within the department.
Yeah. And would you have expected to have seen such a policy in a reasonably competent building control department?
Yes.
Yeah. Now, moving on to the relationship with the means of escape group within the department, you say at paragraph 34 on that same page that you consider it to be a failure on the part of RBKC not to have used the valuable asset of a qualified fire engineer, that's Paul Hanson, to the benefit of the building control department as a whole. And then you say at 35, it appears to me that the working relationship between the means of escape group and the other parts of the building control department was undefined and unclear to those involved, and did not necessarily support project surveyors reaching the most appropriate decisions in relation to Part B of Schedule 1 of the Building Regulations 2010. We see that there.
Yes.
And I think you think that was an underused resource, focusing predominantly on B1 and B5 issues when it could have been used for other issues, including B2 to B4. Is that correct?
That's correct, because a competent building control officer would have a knowledge of B1, seeking support perhaps for complicated escape proposals, and would have a knowledge of B5. I thought it was a strange setup to have a department specifically for those things that should have been general knowledge to most.
Yeah. How common is it for a local authority building control department to have a qualified fire engineer working within that department?
These days it's not uncommon.
Yeah. And at the time of the Grenfell project?
There were building control surveyors with fire engineering qualifications, yes.
Yeah. Where local authority building control bodies have access to a fire engineer, what's your experience of how access to the skills of that fire engineer are used?
They'd be consulted on complex proposals, or proposals that for which there was not government, so shall we say, were not covered in the approved document, but perhaps covered elsewhere by other guidance, or where interpretation of the guidance was questioned, perhaps between the applicant and the building control body.
Yeah. Was the structure of RBKC building control body in that way uncommon amongst local authorities?
Yes, I've never encountered a separate group. It is not clear to me who Mr. Hanson actually reported to, where he sat within the building control department, because he's in a subgroup of what I understand is the building control department.
Yeah.
But he seems to be quite, frank, underused.
Yeah. Are you aware of any reason why there might historically have been a focus on means of escape at the expense of other aspects of fire engineering?
I could make guesses, but I have nothing to support my view.
And one possibility that's been suggested to us is, could this be as a result of the catastrophic Summerlands fire in the Isle of Man in 1973, where 50 people were trapped and died, in which emphasis was put on the need for regulating authorities to ensure full provision of means of escape? Could that be part of the reason why building control bodies like RBKC have such a focus?
I would not have thought so.
No. Okay. Now, pre-application, and looking at the different stages of RBKC's involvement, we know there's the pre-application advice stage, and we know that Mr. Allen, Mr. Gammon and Mr. Hanson provided some pre-application advice on Grenfell Tower, in particular with relation to B1 and B5 issues. Now, you're going to be giving evidence about the smoke vent system in Module 3, so that will come later. But in general, what level of scrutiny of proposed works would you expect from a building control body at the pre-application stage?
It would mainly be via discussion as to adequacy of what was being considered to be proposed. May have been written comments if there was a particular aspect that was contentious. But not to the degree of giving marked drawings back.
Yeah. Would you expect them at that stage to look at the scheme as a whole and note problems or areas where information might be lacking?
Yes, but pre-meetings, pre-application meetings are generally instigated by the applicant because they've got a particular concern.
I see.
And then they would go away and take that. But if there was anything evident, if somebody said, oh, we're going to overclad it, I would have expected somebody to have said, well, what are you going to overclad it with?
Yeah. Well, let's take that kind of example. So we know that the Exova outline fire safety strategy, versions 1 and 2, were provided to RBKC when Studio E sought pre-application advice. Now, at that stage, before the full plans application was submitted, would you have expected RBKC's surveyors to pick up on the fact that there was no in-depth analysis of B4 issues?
It wasn't, it's still not, post-fire it is, but pre the fire, Grenfell, it was not unusual for B4 in the context of the actual wall construction to follow on, because it was probably being discussed at planning anyway. The aspect of B4, I think, that was in the Exova, and it was quite common at the time to comment on that at the very early stages, was the space separation, whereby a fire in one building is not transferred by radiation to another building. And because it's an existing building, it would be necessary to do a full analysis to make sure that if the relevant boundary, which was a notional boundary between the two existing buildings, didn't comply with current standards, it would be set to be most advantageous to the existing buildings and made no worse by the new works.
Yeah. Just to be clear, you said there that the aspect of B4, I think, that was in the Exova was the space separation. I don't think we do see in any of the outline fire safety strategies any space separation analysis.
Correct.
We just see a single statement saying
That's right.
proposals, the changes won't affect this, we'll consider it in a future issue of this report.
Correct.
But I'm interested in your focus on space separation. Would you say at the time that to the extent that building control officers were looking at B4 issues, they were focusing predominantly on space separation, i.e. section 13 of ADB, as opposed to section 12 of ADB, an external fire spread?
I don't think there was any particular focus on B4 full stop, but it was in the Exova. It doesn't actually say space separation, but to me it's inferred that it is the space separation that's being thought about by Exova.
I see. So when they talk about an analysis in a future issue of the report, you think they were referring to space separation?
Yes.
I see. Now, Mr. Allen's evidence was that during the pre-application stages, he was not aware, even in broad terms, that the project involved overcladding. That's day 47, page 176, lines 1 to 16. Would it be common for a building control officer at that stage not to know the broad details of what a project involved?
Well, in my experience, the person who was the applicant, come for the pre-application advice, would give an overview of what was going on. And as the overcladding was a major constituent of that, I would have thought it would have been mentioned, but I honestly don't know if it was mentioned at the time. I can't see anything from the disclosures that I recall.
I see. Would you expect a building control officer to ask for an overall summary of what the scheme comprised for any refurbishment works?
Yes, yes.
Now, moving on to the full plans application, you've said in paragraph 316 of your report on page 98 that you would have expected the building control body review of the full plans application to have been recorded and retained. That's right, isn't it?
Yes.
And you've also said that the disclosed P60 tick list would, in your opinion, have been an inadequate record. That's right, isn't it?
Yes.
Now, can we just look at that P60? It's at page, you've got it on page 66 of your report. Try the next, sorry. We'll find the reference to it. There we go.
Yeah.
Thank you. 65. Thank you. Sorry, that's a wrong reference. So here we can see that form P60, which is the full plans decision tick sheet. Can you just help us as to precisely why you say this was inadequate?
It says pass. I wouldn't think, other than for a small domestic, there would be no conditions attached. It says conditional. Perhaps you would tick it, but there's no place to put any conditions. Condition 1, amended deposited plans. I don't know if that meant it was a condition that you shall amend the plans and deposit the plans, but there's nowhere that you would record what those amendments were required, or in the further plans required, what those plans should address. Rejected, reason 1, does not comply with regulation 4, would contravene regulation 4. Well, that's no help to anybody going forward.
Yeah.
So I'm not quite sure at what stage this would be used on a large project.
Yeah. I mean, how would the decision on a full plans application normally be recorded internally? What kind of document would you expect to see?
In practice, I have used almost like a checklist, A going down,
Yeah.
in my case B going down, and making sure that I address every aspect in looking at those plans.
Yeah.
For a general building control officer, there are 20 approved documents, all of which could apply to a project.
Yeah.
And there's no way they could retain that in their head.
Yeah.
So they'd have to use some form of document to recall what they were doing and to make sure for themselves that they went through a process whereby they were looking at every aspect they had to.
Yes. Now, on that topic of checks that you should carry out, so if we now look at, on page 98 of your report, paragraph 317, at the bottom, you've helpfully explained what the Part B review of the works at Grenfell Tower should have comprised, and you've given us a list, a detailed scrutiny of the fire safety proposals as set out in the plans and documents, an assessment by the building control body as to whether there was adequate detail to allow an assessment to be made, a record of the review noting any variations from recognised guidance. Then if we go over the page, an assessment of whether the proposal was generally compliant as regards B1 and B5 to allow the fire authority consultation, and then the issue of a decision notice as a record of the approved or rejected work. So those are certain key things you say, should be considered just as part of the Part B review. That's right, isn't it?
In my opinion, yes. Yeah.
Now, we know that the hard copy file cannot be located of the full plans application within RBKC, and the electronic records that are held by them are not complete. However, taking into account the documents you have looked at and the oral evidence you have now heard, to what extent did RBKC's review of the full plans application cover the issues you would expect to see as you've set out in this report?
The only disclosure that I've seen that addressed your question would be the documentation produced by Mr. Hanson under his B1 review. B5 is alluded to as regards the dry riser inlet relocation, but overall it's not covered. And between documents and witness statements that I've seen, I'm still not sure what Mr. Hanson was going to give comment on as standard, because Mr. Hoban asked for comments under Part B.
Yeah.
But he only ever get back B1 comments.
Yeah.
So apart from that, there's nothing that I can suggest to you says that that was a review of Part B as such.
Yeah. Now, just then moving on to highlight your conclusions on the substance of the full plans application, and this is set out early on in your report where you've helpfully given a summary of your opinion. If we can look at page 9 of your report, paragraph 37, you say there, paragraph 37, in my opinion, the information submitted to the BCB at the time of the full plans application was insufficient to demonstrate compliance with the building regulations. The BCB ought to have requested further information about the proposed works, and in particular the cladding panels and insulation. The BCB also failed to acknowledge that some information was out of date and contradictory. For example, the fact that the Exova fire strategy did not address the actual proposals indicated on the submitted plans was not mentioned in Paul Hanson's response. So we can see that there. And then at paragraph 38, you state that the building control body, effectively what you say is they should have asked for a new or updated fire strategy. That's in the 4th line. Should have been requested from the applicant to reflect the full extent of the works. That's correct, isn't it?
Yes, the Exova fire strategy addressed the initial proposal. It did not address the additional residential units that were ultimately built.
Yeah. And then at 39, importantly for our purposes on the cladding particularly, you say, as far as I've been able to ascertain, an in-depth review of the cladding was not undertaken. Perhaps we can just move the page down so I can see paragraph 39. Yeah. The disclosures to date indicate that no comprehensive details of the cladding systems were submitted to the building control body for review, and the building control body does not, and if we go over the page, appear to have sought details from the applicant or sought to ascertain or corroborate that the materials individually or the cladding system as a whole were in accordance with the recommendations of approved document B or BS 9991 for a building of this height and use. The failure to ask for detailed information about the cladding system was, in my opinion, a fundamental failing on the part of the building control body. Do you see that there?
Yes.
Just picking up on that, sometimes in your report you've said there was a fundamental failing. Sometimes you've just said there was a failing or a procedural failing. Can you just help us and help the panel? How have you distinguished between those things in your report? So when you say here this is a fundamental failing, what do you mean by that?
By fundamental, I think it's the outcome and the result of not gaining that information. I don't know why there was no cladding package as I describe it, because it wouldn't only address Part B, but it would address Part L for the thermal aspect of the project, which was a major feature. And one of the reasons, as I understand it, the project was undertaken. And there was also aspects of acoustic separation between the units that would have been influenced. So there just seems to be a fundamental failure, as I describe it, a basic failure with far-spreading consequences of not gaining that package information.
Yeah. So where we read fundamental failing, I think you've said there basic failing or serious
Yes.
failing. Would we
Yes.
take it to mean that?
Yes.
Yeah. Now, at paragraph 40, you then go on to say, due to the number of issues found in respect of requirement B1 alone, the full plans application should have been rejected when first received. The plans should have been reviewed in the 5-week statutory time limit. This would have been a simple exercise based on comparison with the P1 annotations. Now, you've explained in detail in your report, and I'm not going to take you through it today because we don't have time, all the reasons why the requirement B1 alone would have justified rejecting the plans. Does that remain your evidence, even having heard the oral evidence of the witnesses?
Yes. Yes.
And then now, if we can go to paragraph 358 of your report, which starts on page 100. Sorry, 328 at the bottom. We can see, and this is picking up at this full plan stage, that Mr. Hansen states in his response that RBKC is not in a position to approve the proposals at this stage due to the need for the design team to establish an acceptable extract rate for the powered lobby ventilation system and the provision of ventilated lobby protection to all stairway connections to residential and other uses. Further details were requested, including the fire alarm system, escape lighting, mechanical ventilation, fire signage, the powered smoke shafts and the alternative power supplies to life safety systems. And then you say the formal consultation with the fire authority was undertaken, and I am going to come back to that later. So in circumstances where that was the position, where RBKC is saying they're not in a position to approve the proposals due to the need to establish all these things, do you consider that it would be acceptable to approve the full plans application in those circumstances?
If there had been given a structured conditional approval, it could have been approved subject to conditions,
Yeah.
but no such decision was made.
No. Yeah. At least as far as you've seen no evidence of a conditional decision being made.
No evidence at all.
No. Now, in terms of the drawings that were submitted with the full plans application, you have helpfully analysed those in paragraphs 277 to 281 of your report. That's on page 88. And you've explained that there are some inconsistencies, mislabeling of the drawings, missing drawings. Now, Mr. Hoban's evidence is that he didn't notice that some of the drawings were missing or mislabelled. That's his evidence at day 45, page 163 to 164. My question is, would you expect a reasonably competent building control officer to have picked up these issues about the drawings that you have identified in your report?
Yes, I would. You'd be looking at the revision number or date, etc., to make sure you had the most up-to-date drawing or indicated that it was. And the fact that it spoke about a music school, I think was quite evident that it was mislabelled.
Yeah. So we have drawings that appear to refer to a school
Yes.
in the label. To be fair, I think they do look like they're Grenfell drawings, but they've got the wrong label.
They're definitely Grenfell footplate, the
Yeah.
footprint rather of the plan, but it's mislabelled.
Yeah.
Definitely mislabelled.
And you would have expected him to have picked up things like that.
Yes.
And you've also referred in your report to the what's called the meaningful response to the full plans application, which is on Accolade. That was the electronic document system that they were using. If we can go to that, that's at RBK 3044876 at page 69. If we can blow this up, this is a screenshot from Accolade, and we can see that the meaningful response is what we see there, where it says requested details of the works John E. Hoban. Do you see that there?
Yes.
And that's said to have been the meaningful response. And you say that in your opinion, that does not describe a meaningful response to a building regulations application. That's right, isn't it?
Correct, yes.
Can you just help us? What should a meaningful response look like in general terms? How much detail would you expect to see?
If it was indicating a total non-compliance, that would probably be an adequate. The submission just indicates a non-compliance in respect of X, Y, and Z. I would expect that to be followed by a rejection.
Yeah.
Or it would be further details required in respect of X, Y, and Z, having established that what was there was a viable proposition anyway, and it was just the main detail that was not available. But the term meaningful response, I'm more familiar with that in terms of approved inspector, where it's used in their various documents and procedures common to an approved inspector. I would expect that to have said approved or accepted or rejected.
Yeah.
But a meaningful response, if it had been in terms of a pre-application discussion, I could understand the term meaningful response. But that may just be my established thinking, and it comes up on accolade. The approval section is a meaningful response, but it says meaning.
It's meaning of response.
Meaning of response.
Yeah, I think in that it's a bit unclear under the action box.
Yeah,
Maybe it says meaningful. Actually, it might be meaningful response. To be fair.
Yeah, I'm not sure what that's meant to refer to.
Yeah. Now, if we can then pick up a little bit more about your conclusions about the cladding aspect of the work. If we go to page 96 of your report, paragraph 303. At the bottom of that page, we've got the heading, the cladding, and you say this: importantly, I have not seen any documents or exchange of emails between any party and building control that refers to the compliance, brackets, or non-compliance of the cladding system external wall construction. As far as I've been able to ascertain, the BCB made no request for details or information regarding the construction of the overcladding and or new external walls at the lower levels and their ability to resist fire spread internally or across their services. Some limited information was provided by the applicant, piecemeal and not specifically related to compliance with requirement B4. No comprehensive cladding package was ever provided. I would have expected such a package to be provided, and if it was not, then the BCB ought to have requested it. So your views are very clear on that there. You talk about that you would have expected a comprehensive cladding package to be provided. At what stage would you have expected that to have been submitted? At the full plan stage or at a later stage?
At a later stage, but certainly before the works commenced or in the very early stages of the works,
Yeah.
just in case it had to be taken off and replaced.
Yeah. And would you expect there to be a clear statement from the applicant that it considered the design complied with B4 as part of that full plans application or part of the information that followed it?
Yes, and if it was not evident, then I'd ask for justification of that statement.
Yeah. Now, Mr. Hoban gave evidence that he passed the full plans application, but with conditions. That was his oral evidence. And he said that one of the conditions was the cladding system shall be in compliance with section 12 of ADB. Please provide further information. That's what he says one of the conditions was. This is day 45, page 189, lines 2 to 7. Now, again, it's going to be for the panel to decide whether they accept that evidence by Mr. Hoban. But just sticking with it for the moment, if such a condition was applied, does that represent the sort of condition that would be applied in circumstances where information was lacking?
Yes.
So for him to say the cladding system shall be in compliance with section 12 of ADB, that's the kind of condition you think would be reasonable to impose?
Yes.
Yeah.
Well, can we just have a look at that a bit further? I thought as a result of our exchanges this morning that you had told me that the condition would be a condition of submitting further plans, not doing it correctly. And there is quite an important distinction, isn't there? Because building control's role is to ensure that what is proposed will be in accordance with the regulations if it's constructed in accordance with the proposal.
Yeah, so the wording that Mr. Hoban says he used would normally have been followed by full details shall be submitted
Right.
to indicate compliance.
Before the work was done.
There's nothing that building control can do to stop the work starting.
Right.
It can go onto site and find a non-compliance and serve a notice if they don't change it by good word. There's nothing to stop the work going ahead. They would do that at their own risk, carrying on with the knowledge. Hopefully he would have told them that if you carry on and I'm not satisfied, then it could end up that all this work needs to be undone.
But that seems rather a complicated way of going about it. You'd have thought the preferable course would be to impose a condition saying, I'm passing this on condition that you provide me some plans which demonstrate compliance.
That is what you would do. As I say, the work shall comply with B4, full details shall be submitted. What would normally happen is that the applicant would make the statement, the work will comply, and then building control would say, prove it to me, show it to me on the plans.
Yeah.
Right, thank you.
Yeah.
Yes, it's Grinch.
Yes, thank you. Sticking with that theme, if we could go to paragraph 244 of your report on page 61. You say, a conditional decision will also request details of elements, installations that may not be available at the time of the initial submission. And then you say this, any request for details of the overcladding should have, at the same time or following their receipt, required the submission of any fire tests or assessments to attest to whether the relevant materials were of limited combustibility, surface spread of flame, fire resistance of the individual materials, and or assembly forming the overcladding. Do you see that there?
Yes.
Now, just to be clear, you say there any request for details of the overcladding, but can we be clear, in circumstances where you say it would have been acceptable to apply a condition that you apply with a part of ADB on B4, would it also have been expected that those details would in fact be submitted?
Yes.
Yeah.
Yes.
So you as the building control officer wouldn't just leave it to them, just say you've got to comply with section 12, then leave it to them. You would require proof that it had or was going to comply, and the type of information you would expect is what you're describing here, including fire tests and assessments. Is that right?
Yeah, my answer to you previously was incomplete. I should have had always, wherever you request details, you always request details on every aspect to prove to you that it is compliant. If they said the walls are going to be made of 120 mil masonry block throughout the height, you'd probably have taken that as acceptable, but you would have asked for how would you restrain those walls, etc., etc.
Yeah. Just then, taking the Grenfell example specifically, for example, for the ACM panels on Grenfell, if the drawings had shown ACM panels, what, in your opinion, ought to have been requested by the building control officer in relation to the compliance of those materials?
Details of the individual materials and or an assessment under BR 135, or as set out in the Building Control Alliance, an assessment, a fire engineered proposal to support their statement that they thought it complied with the building regs.
Yeah. And again, would you require the same for the insulation product to be used? Would you require some supporting test evidence or other certificate that suggested that insulation was compliant with the requirements either of ADB and the linear route, if that's what they're following, or a BR 135 certification if they're following the system testing route? Is that right?
Yeah. If the components of the wall had individually been known to be non-combustible, then the details of the insulation would be requested to make sure that that was non-combustible. But you it should be known to a building control officer that materials in combination do not always work as individual materials. So if you mix combustible and non-combustible, you may still be up to the required standard, or you may be quite the converse by virtue of the reaction of the combustible materials relative to the ventilation paths and the backing material and the support.
Yeah. And you would have expected a reasonably competent building control officer to have been aware of those matters, would you, that you were just describing?
Yes.
Yeah. Is it realistic to expect that an applicant will be able to provide test data and supporting evidence of compliance at the full plan stage, i.e. before work has commenced on site?
If they were proposing a material that formed part of the submission, albeit it was still in negotiation perhaps with planners, by virtue of the fact that they were proposing it, they should then go to the manufacturers, the suppliers, to get that test evidence.
Yeah.
It's down to them to provide it.
Yeah.
The most manufacturers, if you approach them for their test data, will not give it to you because they fear it would be commercially beneficial to other parties. But if you're buying it off them, they seem to be more willing to actually give you the information. And sometimes you have to sign a non-disclosure agreement.
Right.
But it is available.
Yeah. And would you say you sometimes have to be persistent about getting hold of that information?
Yes. I mean, sometimes the applicant comes back and says, they won't give me one. They won't give me the test certificate. And, well, go back and tell them that you need it, otherwise you can't use their material.
Yeah. Now, you and Mr. Hyatt have come to the conclusion through a review of the documents that there was no form of tracker used by RBKC Building Control to monitor the refurbishment. Would you accept, though, that there was no specific requirement for local authority building control services to operate a tracker system for such applications?
That's correct.
In your opinion, would a reasonably competent building control body have in place a tracker or an equivalent to a tracker to monitor the progress of that application through its life cycle?
Yes, and I know that many building control officers in all different offices, even if there's no policy within their office for such a tracker, set up their own trackers, or quite often they're instituted by the applicant or generally the architect, because everybody's got so much to deal with. That's a way of dealing with the regulatory side as regards building regulations.
Yeah. Now, Mr. Hoban has described his plan check record sheet to the inquiry. He referred to that in his oral evidence at day 45, page 79, line 19. Do you know what he was referring to there? Are you familiar with something called a plan check record sheet?
Yeah, I mean, there's no set formula for it. It'd be probably a spreadsheet or something he may have devised individually, or it may have been in the office, where it would be effectively an aid memoir and a record of what you'd look at and what you'd come to the conclusion of.
Yeah.
Because when you get all that information in, it's a quicker way of referring back to the initial review to see what you were looking for and the particular aspect of what you were looking for. It just helps the process all the way along. It improves efficiency and it records. If you haven't got a record and it's months between, you don't know, you don't want to do it twice.
Yeah.
So
but is that,
speak.
sorry,
No, carry on.
but is that the same thing as a tracker, or is a tracker different?
A tracker usually comes after the decision.
Yeah.
Because it'll have the conditions, if any were on it. The record is your record of your work going through and recording what you found, acceptable or not. Now, if it was you with a detailed initial decision sheet, whatever you want to call it, you can in fact then turn that into the tracker.
Yes. But they're not the same thing.
Not in my mind, no.
Yeah. Now, I'm going to come back a little bit later because the next stage in the process is consultation with the fire authority, but I want to press on at the moment with your main conclusions, and we'll come back to that topic. So now, assessment of compliance. What I want to do is take you through RBKC's assessment of compliance with Part B of the building regulations. and just pick up what your overall conclusions were. Now, we've already discussed B1, means of escape, and the full plan stage, and your evidence that it should have been rejected purely on B1 grounds at that stage. But I just want to pick up your overall conclusions. And for the transcript, in paragraphs 355 to 341, on pages 101 to 105 of your report, you've summarised the updated information that was provided by Studio E and also the second consultation with the Fire Authority. And at paragraph 342, you conclude that although you've highlighted several issues with the proposals, your view is that the review of the later proposals, the S2 proposals, i.e. the updated fire strategy drawings and the smoke control system proposals, was adequate and acceptable. Is that correct?
Yes, in relation to B1, yes, yeah.
And that aspect of the building control application was reviewed by Paul Hansen. That's right, isn't it?
Yes.
Yeah. Now, in terms of your conclusions on B2, internal fire spread linings, they're set out at 346 to 349 of your report on page 106. And again, just to try and get to the nub of your overall conclusion, you say at paragraph 347 that part B2 was addressed in the ex-over outline fire safety strategy version 3 of November 13, and it fully reflected the recommendations of approved document B. Is that right?
Correct.
And that at the end of that paragraph, you note that the ex-over fire strategy did not reflect the proposals. Does that have a bearing on your overall conclusion that the information submitted to building control demonstrated compliance with the B2 condition?
B2, if it stated it will comply, you would look... From my aspect, I would then, if on site, and it was other than something I knew and recognised as being acceptable,
Yeah.
I would then, at that stage, ask for the details.
Yeah.
If it had been a hotel, shall we say, or a high-end office block boardroom, I would have asked for details because I would know it would not be emulsion on block. It would be some laminate or something like that, and I would ask for details or evidence that it complied.
I see. So depending on what they're choosing to do with their internal linings, that might affect the level of scrutiny you gave to that.
Yes.
Yeah. Now B3, because the key things for our purposes are predominantly B3 and B4. Now, in terms of cavity barriers, and turning first to cavity barriers around openings,
Yes.
you say at paragraph 390 of your report, page 114, perhaps we can just bring that up. You say there, picking up in the second line, the building control body failed to recognise that no cavity barriers had been indicated to seal the cavities at openings within the walls, for example, around the windows. We can see that there.
Yes.
Now, just breaking that down, would you expect a cavity barrier strategy showing the location of cavity barriers to be submitted at the full plan stage?
Not necessarily. Quite often it's covered by a statement that cavity barriers will be provided around all openings
I see.
to close the cavities.
So if you saw that kind of statement, you might not worry that they weren't marked in the drawings. Is that what you're saying?
At that stage, yes.
Yeah.
Yes.
But what if there was no such statement, and what if the drawings you had as part of the full plans application didn't show any cavity barriers around the windows? Would you expect that to be picked up at that stage?
Yes.
Now, if we can just look at Mr. Hoban's evidence on this topic, and I want to look at the transcript of his evidence here. This is day 46, page 95, and I want to pick it up around line 6. So this is Mr. Hoban being asked questions by Mr. Millett, and at line 6 he says, looking at this one, did you notice that there were no cavity barriers indicated at the head, jamb or sill of the windows? And then he says, it was my understanding that the framework supporting the window would act as a cavity barrier. And then he's asked, what was the basis of that understanding? And then he says, if you look at approved document B, it calls up that a steel framework over a certain thickness can act as a cavity barrier. And then it says, yes, I don't want to argue with you, but that's right, isn't it? Only if it's made of a particular material like steel. And then he says, answer, metal, steel, yes. Question, steel, not aluminium. And he said, yes, from my understanding, it was steel. Do you see that there?
Yes.
And then if we just, before I ask you some questions, look at what he says just over the page, at page 96. He's asked, who told you that? And he says, I can't say. It was always my understanding that the framework supporting the window was of a thickness of steel that could act as the cavity barrier. And then question, well, it could as a matter of theory under ADB. My question is, did you ever see any drawing, any plan, any note, or have any discussion? And then starts answering, but then it says, let me finish the question, please, about steel being the material used in those positions to act as a cavity barrier. And he said, that was, as I say, my understanding. Now, that was his oral evidence. And I want to ask you, have you seen anything in the information provided to RBKC Building Control that could have led Mr. Hoban to conclude that there was steel framework supporting the windows?
No. Not that I can recall.
In circumstances where an applicant is relying on a steel framework of a window instead of a cavity barrier, would you expect this to be recorded somewhere in the submission to Building Control?
Yes.
Would you expect it to be clearly indicated on a drawing?
Or a statement down the side of the drawing or in the details submitted, yes.
Yeah. And what inspection would you expect a building control officer to carry out on site in those circumstances where you've then been told that information?
To go and, on the assumption it was steel, to go and make sure the steel was of the requisite thickness and to make sure it was forming a barrier between the cavity and the opening.
Yeah. So you'd actually go and do some checks for yourself. You wouldn't just take their word for it, that the steel was going to be compliant with a cavity barrier,
Yes, yeah.
or synonymous with a cavity barrier as given in the guidance in ADB, yes?
Yeah. Wouldn't look at every opening. Wouldn't be there long enough on a daily basis to do it. But you would judge by the standard of the work generally how often you would go
Yeah.
and check and
Yeah.
to what extent you would do check.
Yeah. Now, Mr. Hoban's evidence was that he did not check around the windows because when he visited the site, the windows were either not there or had already been enclosed. For the transcript, that's day 46, page 98, lines 8 to 25. In your opinion, should he have asked to have a window removed so he could inspect it if he couldn't otherwise see what was around the windows?
It would have been a decision on the knowledge of the particular job and the standard of the work, etc. But if he hadn't said that, I would have expected him to have said, when you're not going to put that window in the opening, I want to see it before it goes in.
Yeah.
Something like that to check that there was at least the... Again, a lot of it is judgment of the person that you're dealing with and the standard of work.
Yeah.
But in best practice, it would have been to take the window out and have a look.
Yeah. Or, as I think as you've said, one possibility would be then arrange a specific time to
Yes.
visit in the future when he could be shown an area around an installed window before it was covered up. Yes?
Correct, yes.
Now, you say at paragraph 396 on page 117 of your report, let's just look at that. Yes, and this is a bit of your report where what you're discussing is what was shown on the Studio E drawings. And if you recall, on the Studio E drawing, as you note in the middle of this paragraph, you note that in the Studio E drawing 12790612000, there is a cavity barrier above the head of the window in line with the compartment floor. Do you recall that?
Yes.
And you say this, in principle, a building control body may have considered this cavity barrier to be effective as a window cavity barrier. However, I've seen no evidence that John Hoban adopted this approach. And then you go on and explain what the Harley drawings showed.
Yes.
Now, moving on to your conclusions on cavity barriers within the cladding system at compartment wall and floor lines, you've explained the history of this in your report at paragraphs 363 to 389 on page 113. And I just want to focus on your opinion about the standard of fire resistance required by the cavity barriers. Now, what we know is that Mr. Hoban, in March 2015, initially advised that fire stops were required and that these should be 120 minutes fire resistance. Do you remember that?
Yes.
And then eventually he changed his mind, having been provided with some further information, and advised that only a cavity barrier was required at compartment wall and floor lines. You recall that?
I don't know why he changed his mind. There's nothing that's been disclosed to me, the reasoning behind his ultimate decision. There is a confusion between a cavity barrier and a fire barrier to maintain compartmentation. The big debate with rain screen is where that fire barrier sits. I believe that was the whole debate that was going on, and there is still some discussion within the industry at the moment.
Yeah. I'm going to take you to diagram 33 in a moment, and you can just explain that to us. Let's just look, before we get to that, at what you say in your report. So you refer to diagram 33 in your report at paragraph 381, and again at 382. If we can go to 382 on page 112. You say this, it's consistent with exactly what you've just been saying. This diagram caused much debate in the industry at the time of the application and continues to do so. The debate centred on whether the required cavity barrier in a rain screen cladding system should be 30 FR or the same as the fire resistance of the compartment lines the cladding passed over. The compartment lines at Grenfell were between the flats and between the flats and any other areas. And then if we can just look at what you say at 386 on page 113, you say, if I had been the building control officer on the Grenfell refurbishment, I would have required 120 FR fire stop at compartment lines to extend compartmentation out through the rain screen system. This would have been the starting point, and I would have required any proposals to use 30 FR cavity barriers in these locations to be justified.
Yes.
So that's your view there. If we can look at the version of diagram 33 that you've helpfully provided in your report, this is on page 111. Now here, if we blow this up, what you've helpfully done is change some of the colour coding so that here we've got the fire stopping is in green and the cavity barrier is in blue, which makes it actually clearer looking at this diagram than in approved document B.
Yes.
I think that's why you've done it, is that
Yes.
right? Yes. So blue are cavity barriers and green is fire stopping. Now, do you agree that for this building that's being shown here in this diagram, it appears to show cavity barriers in the location between the external wall and the rain screen cladding, i.e. the little blue rectangles? Yes?
Yes. This diagram is on the assumption that the wall complies with the requirements of B4.
Right. Yeah. So is what you're saying that where there's perhaps some doubt about whether the B4 requirement is met, you need to potentially apply a higher standard of resistance to the cavity barriers and make them equivalent of a fire stop? Is that what you're saying?
My view is that this diagram doesn't actually relate to rain screen cladding.
Yeah.
It reflects a cavity wall. And the weather line and the thermal line can vary on rain screen cladding. This looks like a cavity wall where the thermal line would be effectively inside. So the compartmentation from, say, the floor goes up to the external wall, which would be to standard.
Yeah.
In a high-rise building, it would be
Yeah.
effectively
So
non-combustible.
that's the green bit, is that what you're saying?
Correct.
The green bit takes you to a solid wall.
Yes.
Yeah.
And then there's a cavity in the wall that needs to be subdivided to stop the unseen spread of fire.
Yeah.
And then there are, around the openings, there are cavity barriers to stop fire from the compartment going into the cavity and then spreading beyond the cavity.
Yeah. So, but applying this and assuming a rain screen on the outside, can you just explain to us why you get to a slightly different result in a rain screen application?
Why I think the compartment should be continued through the rain screen.
Yes, and why you need a 120-minute fire stop where the little blue square is,
Right.
rather than a 30-minute cavity barrier.
To my mind, there is potential for a fire in the compartment which is stopped by the green on the end of the compartment, breaking into the cavity where the blue stops are and spreading up to and entering another compartment. So therefore, to my mind, the compartment line should go out as far as possible such that any void is fire stopped, has a fire barrier in it.
Yeah. And why do you say there's that potential for fire to break out from the compartment if you've closed around openings with cavity barriers?
Because it can go up and go back in.
Right, I see. Now, in paragraph 383 of your report on page 112, you say that this diagram is only an indication of where, in principle, to locate cavity barriers and fire stopping to deter the unseen spread of fire.
Yes.
Yes. Can you just help us as to what you mean exactly by that? Why is it only an indication? Is that because you were saying it applies perhaps more to a standard masonry construction?
Yes, it applies to the majority of whatever one determined would be normal buildings.
Yeah. And you refer to a debate in the industry on that topic. Can you just help us as to what that debate was at the time?
Some people take the diagram 33 and apply it to every form of external wall. Some of us don't agree that it's relevant to a rain screen cladding. And again, the rain screen cladding is not a standard formation. And so it will depend on what that rain screen cladding is made of and the extent it continues beyond compartment lines. But that diagram 33 sets out the principle of fire stopping to maintain compartmentation, cavity barriers to stop the unseen spread into the cavity and through the cavity.
Yeah.
So you would apply that principle where the debate comes, where you're sitting down discussing where with somebody the barriers are appropriate or not.
Yeah. And just to be clear, on either interpretation, it was clear, wasn't it, that cavity barriers needed to be provided around openings?
Yes.
Do you agree that it is cavity barriers, not fire stops, that are referred to in some of the industry guidance giving assistance about external walls? For example, in BCA Technical Guidance Note 18, under the heading Key Issues, that talks about the importance of cavity barriers rather than fire stops. Do you agree with that?
What are they in the context of? Sorry.
Yeah, let's look at that. CEP 30/57294 on page 1. This is the Building Control Alliance Technical Guidance Note, use of combustible cladding materials on residential buildings.
Mm-hmm.
And then under key issues, it's talking about fire spread is exacerbated by the use of combustible materials. Statutory guidance addresses these issues in the second paragraph. And then in the last bullet, it says, so it starts with a surface spread of flame classification does not infer any resistance to combustibility, solely a measure of the spread of a flame across the surface. And then it says the BR135 BS8414 test deals solely with the spread of fire once it's entered the cavity. Hence, the requirements for cavity barriers in accordance with Section 9 of ADB2 are required in all cases, including around openings in the facade. Now, I appreciate that this isn't saying it's just specific to rain screen systems, but this guidance at the time suggests that it's cavity barriers that are required.
I would suggest it's talking about when the fire has entered the cavity, stopping it spreading,
Yeah,
and it's not specifically relating to maintaining compartmentation.
I see. I see. Now, at paragraph 387 of your report, you say that there's logic in questioning the rationale of a fire barrier in a cladding system that has no fire resistance and may, when attacked by fire, fail and collapse within 30 minutes, thereby rendering any fire stopping or cavity barriers ineffective. Yes. Now, what do you mean by the cladding system failing in that context?
In very few circumstances, the external wall would have to be fire rated. Generally, I've never seen a rain screen cladding that has had to be fire rated, which means it doesn't have to withstand fire from inside the building for any particular time. If it's aluminium, it will fail relatively early in a fire.
Yeah.
So it could be you could have a fire raging in a 2-hour building and the cladding has fallen off. Then there is the question, if you have the cladding disintegrating, falling off, or even just bowing, is that cavity barrier going to have any effect whatsoever?
Yeah. In your view, does that risk of failure justify omitting cavity barriers entirely?
No.
Why?
Because the cavity barrier will, and the rain screen will be there for a period of time, by which time, hopefully, other measures may have come into play and definitely the evacuation will be underway. The big risk then comes, well, there's a bigger risk of the falling cladding falling onto firefighters, which is why we would generally aim to put the entrance and the set-down point for firefighters away from the potential for cladding to fall onto them.
Yeah.
There have been stories of large sheets of glass falling out and literally cutting through the hoses that are going into the buildings.
Right, yeah. Now, on this point about whether it should have been a fire stop or a cavity barrier, your overall conclusion is that requiring a cavity barrier instead of a fire stop was within the range of reasonable responses for a building control body at the time. That's right, isn't it?
I think so, yes.
Yeah, so you say there's a debate, there's different views on it, but you're not critical of Mr. Hoban for ultimately accepting a 30-minute cavity barrier in that location. Is that right?
Yeah, I think a number of building control officers would have come to the same conclusion.
Do you find it surprising that Mr. Hoban, despite his years of experience in building control, had never advised on diagram 33 in the context of a rain screen cladding system? That was his evidence at day 46, page 123, lines 7 to 10. In your experience, would it be surprising for someone, particularly of his length of experience, not to have come across and had to deal with diagram 33 before?
Yes, particularly if he's worked as he has in an urban situation.
You do find that surprising?
Somewhat surprising, yes.
Yeah. Now, finally on this issue, you've commented on the crown at paragraph 405 on page 123, and if we could pick that up. Page 123 of your report, 405. you say, finally, as far as I can ascertain, the building control body was not provided with any detail of how the crown of the tower was to be constructed, clad. The initial submission of details in September indicated zinc crown elements, but this was changed. I would expect that once the BCB saw the crown on site, he should have asked for further information. I've not seen any evidence that this was done. The site visit notes make no reference to the crown. I now know from inspections by others that no cavity barriers were installed at the junction between the rain screen cladding system and the crown, or within the crown itself. In my opinion, this ought to have been noted and questioned by the BCB. Now, it's right, isn't it, though, that there was nothing, say, in approved document B, which assisted about whether you should have cavity barriers in an architectural feature like a crown. That's right, isn't it?
Correct. My statement is that ought to have been noted and questioned by the BCB. He may have come to the conclusion that they didn't need cavity barriers.
I see. But you think it should have been something he was thinking about when he was looking at this building?
Yes.
Now, Mr. Hoban's evidence was that he inspected the crown on site. That's day 46, page 148, line 3. If that evidence was to be accepted by the panel, and again, that's going to be up to their assessment, and if we assume that he did inspect it on site, do you have any comment on what he ought to have noticed or recorded in his notes of any such inspection?
I'm presuming he looked at it from a structural aspect if he wasn't interested in it from the fire aspect, but it should have registered with him what the material was.
Yeah.
And questioned whether it constituted part of the external enclosure or was an attachment, which, again, since the fire have become quite prominent, controlled. Prior to that, as you say, there was nothing as regards an attachment, an architectural feature, but I would have expected him to have looked at it as to if there had been a fire, what would it have caused the fire to progress?
Yeah. His evidence was also that his understanding was that cavity barriers were not required within the crown because it was not a concealed space. That was day 46, page 102, lines 10 to 21. Do you agree with that?
I don't know the full details of the construction of the crown, so I couldn't, without seeing the details, comment on that.
Okay. He also said that he considered the cavity barrier at the head of the window at the very top of the building would act as a cavity barrier at the junction of the spandrel cladding and the crown. Again, that was day 46, page 103, lines 17 to 18. Do you agree with that cavity barrier at the head of the very top windows, before you get to the crown above, would have acted as a cavity barrier in that location?
Without looking at the plan at this point, I couldn't say, or the elevation. But irrespective of where the cavity barrier to the opening was, as there was no barrier to the side of the opening, if the fire could have gone sideways and then up and spread into the crown, that would have been a concern.
Yeah. Now, we've heard evidence during this inquiry, oral evidence, that in fact, on site, the horizontal cavity barrier above the head of the window was moved even further up from the location shown in the Harley drawings. If you remember, it was shown at the head of the window, immediately at the head in the Studio E drawings.
Yeah.
It was shown slightly higher in the Harley drawings. And then the evidence of Osborne-Berry to the inquiry was that on site a decision was taken to move it up even further than that. Now, is that something you would have expected Mr. Hoban to have noticed on site as part of his site inspections, that the cavity barriers, the horizontal ones, were located higher up than shown on the Studio E or Harley drawings?
As a general rule, building control officers don't walk around with all plans of everything, but as he wasn't looking for cavity barriers at openings at all, he probably would not have noticed it had been moved up. But the principle of having it at or about the opening should have registered with him. The fact that it had moved slightly probably wouldn't have registered with him.
Yeah, okay. Now, B4, on your conclusions on B4, we know that no comprehensive cladding package was ever submitted, and we've looked at your views on that already. But I want to briefly explore with you how the guidance in approved document B should be interpreted and should have been interpreted. You've set out your views at paragraphs 413 to 419 of your report, pages 126 to 127. At paragraph 414, you've referred to paragraph 12.5 of approved document B. And we know that the cladding on Grenfell Tower purported to follow the linear route, i.e. the guidance in approved document B, except perhaps for the insulation where it seems possible that an 8414 test plus BR 135 may have been relied upon, at least by some of those responsible for the design of the cladding. Do you have a view as to whether it is appropriate for a project to pick and choose which route to compliance applies for different materials in a rain screen cladding system?
You can't, in a composite, unless they are all totally non-combustible, I don't think you can pick and choose which bit goes to make up that composite. That composite as a whole must be looked at, and the effect of one material on the other.
Yeah. Now, Mr. Allen seemed to suggest in his oral evidence that if the linear route was adopted, you know what I mean by the linear route, you follow 12.6, 12.7 of ADB rather than your BR 135 route.
Yeah.
So it's the two routes that are suggested in 12.5 of ADB. Now, he seemed to suggest that if the linear route was adopted and the insulation was not of limited combustibility, this would be non-compliant. Do you agree?
He said that the insulation was non-compliant or non-combustible. Sorry, could you repeat?
He said if the insulation was not of limited combustibility, this would be non-compliant. Do you agree with that?
Yes.
Yeah. That was day 47, page 29, lines 12 to 20. Now, you refer in your paragraph 415 on page 126 to paragraph 12.6 of approved document B, which addresses the external surface of walls and the requirement that over 18 metres the external surface should achieve, one option is should achieve national class naught. Would you expect a reasonably competent building surveyor to understand what national class naught means?
Yes.
Would you expect them to understand that you can have a product where the surface achieves class naught, national class naught, but it nonetheless contains combustible material inside?
Yes.
And would you expect them to have an appreciation of the risk in terms of external flame spread that limited testing to national class naught might pose?
Yes, because it's purely a surface spread of flame description.
Now, in paragraphs 416 and 417, you give your interpretation of paragraph 12.7 of approved document B. If we can just look at the text of ADB there, if we go CLG 50173 at page 96. So there we have 12.7. It will be very familiar to many of us by now. We've looked at it a number of times in this inquiry. Now, you say in paragraph 416 of your report that you interpreted 12.7 as referring to elements of the wall, but not the fabric protecting the building against weather. Can you help us as to what you mean by that?
The wall in itself comprises of those components. When I refer to the aspect of weather, I'm trying to recall why I've phrased it in this particular way.
Would it help to see the passage in your report?
If I may.
Yes, I'm sorry. So paragraph 416 of your report. On page 126. So there you've set out in the first half of that, in the first few lines, a quote from 12.7. Sorry, that's a quote from 12.5.
Yeah.
And then you say the requirement required resistance to the spread of fire over the walls and from one building to another. Then you say this, 12.7 of ADB referred to any insulation product, filler material, except gaskets, sealants and similar, etc. I interpreted that as referring to elements of the wall, but not the fabric protecting the building against the weather. Do you see that there?
Yes.
And we were just wanting you to just try and help us as to exactly what you meant by that.
To be quite honest, I'm struggling myself to explain why I've put it in that particular way.
Well, tell us what you
Let's go
were
back.
trying to say, and then we'll worry less about the words you chose.
Yeah. I mean, do you want to go back to 12.7 of ADB? Would that help?
Yes, please.
Yes. So that's CLG 50173 at page 96.
Right. The components that make up that wall as a whole, or the components of the wall, well, it's entitled the insulation materials.
Yeah.
So and it quite clearly says that it should be of limited combustibility where the building is over 18 metres.
Yeah.
The intent of B4 is to stop spread of fire across the surface of the building, which would not necessarily be the insulation of the building.
Yeah.
Most insulants require protection, I think I'm right in saying, against the weather because they would deteriorate.
Yeah.
So it's almost like two distinct aspects. So it's the insulation needs to be limited combustibility, and then the wall elements that make up the external aspect of the wall
Yeah.
have to have a surface spread of flame restriction
Yeah.
and a limited combustibility in themselves.
Yeah. It's where you get that limited combustibility from that is interesting. We know in 12.6, the paragraph before, that it says that external walls have to meet certain requirements, and that's where we get national class naught, above 18 metres in diagram 40, for example, as it applied to Grenfell. But can you help us as to why you think that the external wall element also had to be of limited combustibility, not just the insulation?
By virtue of is it 12.5?
Yeah.
If we go back, could we go back down?
Yes, of course. If we go back, I think one possibly... Yes, there we go, at the bottom of that page.
Yeah.
We've got the general warning in 12.5 at the beginning. The external envelope of a building should not provide a medium for fire spread if it is likely to be a risk to health or safety. The use of combustible materials in the cladding system and extensive cavities may present such a risk in tall buildings. Is it that part of 12.7 which you're saying then informs how broad you think you ought to interpret 12.7? Is that right?
Yeah. Well, 12.7 relates specifically to the insulation.
Yeah.
This is the external wall construction.
Yeah.
And the limited spread as dictated by 135 or compliance with 12.6 to 12.9 inclusive.
Yeah.
So, and 12.6 to 12.9 cover, as it says, external surfaces, the surface spread of flame externally.
Yeah.
So if a refuse bin caught to light, what would it do to the surface? How fast would the flame spread up the external surface? Then you've got the insulation, and then you've got the actual components forming the overall format of the wall.
Yeah.
Hope that helps.
So I think what you're saying is that the external surface is, here it would be the rain screen. Are you saying that you need to look at it from two angles? One is its external surface, and the other is whether or not it could propagate fire. Is that what you're saying?
Yes, they are two distinct things in my mind.
I see. And is that why you then interpret 12.7 perhaps more broadly than others do?
I didn't realise I did.
Right.
But to me, there is distinct, the external surface, limited surface spread of flame, whether you adopt the national class or the European class.
Yeah.
The overall wall construction must not propagate the spread of fire.
Yeah.
That will include in the test the reaction of the surface spread of flame.
Yeah. Now, if we can go back to 417 of your report on page 126, yes. So there you say this: my interpretation of the recommendation of paragraph 12.7 was that for a building such as Grenfell Tower, the elements of the external wall, save for gaskets and sealants and similar, should be of limited combustibility, as that interpretation reflects the overall functional requirement of B4. This view is also supported by BCA Technical Guidance Note 18, which I have referred to elsewhere in my report, and which states that the insulation, internal lining board and external facing material should be of limited combustibility. And then you say that in December 2018, you think some amendments have clarified that, but in your view, that was clear already. Is that what you're saying?
Yes.
Yeah.
I think what the amendment subsequent to the fire related to was the question over what they termed as the insulation in the actual ACM panel, which to me was not insulation in terms of the insulation referred to in the approved document.
I see. So you accept it's not insulation, and so strictly it's not the kind of product that 12.7 seems to be primarily focused on.
Yes.
Do you agree with that?
That was my interpretation at the time, yes.
Yeah.
It was, to me, it was a stiffener, if anything. And I, like many, assumed it was completely encapsulated within the aluminium.
Yes, we're going to go on to that in just a moment. So you've also said that you don't consider the core of an ACM to be a filler within the meaning of how that term is referred to in 12.7. Is that right?
Correct, yes.
And is that because you've said that the core provides, quotes, little insulation? Is that why you say it's...
To my mind, at that time, filler would be something like you put in an imperfection of fit,
Yeah.
A material you'd use to infill a gap to form a shadow gap or similar. It would not have been in the terms of that material within the actual cassette panel.
Yeah. Was there a view at the time...
If we're going to pursue these sort of questions, I wonder whether they ought to be by reference to the understanding within the industry rather than the witness's personal...
Yes, absolutely. That's fine. Yes, I was about to ask that very question.
I was also going to ask you whether we're getting...
When we're going to break. Yes, don't worry. I've got that...
Right.
Just a couple more questions and then I think we can break.
Very well.
Was there a view held at the time within the industry that the core of an ACM panel might be, quotes, filler? Were you aware of that view at the time?
Personally, no.
But were you aware of others within your industry sharing your view as to how 12.5 through to 12.7 should be interpreted?
I can't recall at that time any major discussion, to be quite honest. I cannot recall any discussion where what the government now calls filler was being discussed. But that is just my involvement in the industry at that time.
Yeah. Mr. Chairman, I'm midway through this topic, but we're coming on to a slightly different subtopic now, so I think we'll break.
I think we probably should have a break at this point.
Thank you.
Which means if we're going to have another break now, we'll come back at 22:04, please, and no talking to anyone, well, about your evidence, that is, while they're out of the room. Right.
Okay.
Thank you very much. All right, thank you. 22:04, please. Okay. Thank you. Do you ask Mrs Menzies to come back in, please? All right, happy to carry on.
I am. May I clarify a response that I made earlier?
Of course.
I believe you asked me whether there was a debate in the industry
Yes.
about cladding.
Hang on, which debate? We've talked
About the actual cladding and what it comprised of and the solution to dealing with it.
in terms of cavity barriers and fire stopping, or in terms of how 12.7
12.7
applies?
etc.,
Yeah, okay, yeah.
I feel the debate, to my mind, was before the full plans application, the cladding at Grenfell, and that had been, the response to that was the BCA Alliance Technical Note 18.
Yes.
So that, in my mind, and I think the industry's mind, that was the solution that you went forward with. So as to, I'm not saying the debate wasn't going on, but it wasn't a primary debate on the forefront of everything at the time.
I see. So you're saying in June 2014, when the BCA Technical Guidance Note 18 comes out, referring to, I think, like all key elements of the wall being limited combustibility, in your view, the debate was settled at that point, was it?
That was the view at the time of the way that to deal with the aspect of the composite cladding, yes.
Right, I see. Thank you, thank you. Now, at paragraph 436 on page 135 of your report, you've said that in the first few lines there, I believe it was generally thought at that time that an ACM panel fully encapsulated the core material in the panel, and that panels were not generally cut on site, i.e. that the core material was not exposed. Can you explain why you think that that was the general view at the time, that these panels were fully encapsulated?
When I had discussed them previously on projects, that's how they were described to me, and post-fire, discussing it with various colleagues, several had agreed that they thought they were, like I did, fully encapsulated.
And can you just explain how that was relevant to what building control officers ought to have been doing at the time?
Well, the exposed face would have been another exposed face of a combustible material.
And something that you think Mr. Hoban should have noticed on site?
Yes.
Yes. Now, just to finish off your conclusions, your conclusions on B5, access and facilities for the fire service, are at paragraph 451 to 460 of your report. That's pages 137 to 139. And then at paragraph 460, you say that the smoke control system will be the subject of a separate report. That's right, isn't it?
Yes.
At this stage, are you able to give any view about whether the assessment for compliance with B5 was appropriate?
I think the assessment was appropriate, but I am unclear as to the conclusion as what the final system was, because the acceptance of the system preceded some amendments required by building control that I don't actually know whether they were carried out and what they actually related to.
Yeah, that's helpful. Thank you. Now, at this point, I just want to go back to the question of consultation with the fire authority, which we've referred to a number of times. Now, you deal with that topic at paragraphs 298 to 299 of your report on page 96. And just for the benefit of the public and those who've not read your report, I'm just going to summarise what a fire authority consultation is, and you can just tell me if you agree. Is it right that Article 45 of the 2005 order requires a local authority in receipt of a full plans application for a building or part of a building that will be the subject to the 2005 order on completion of the works to consult the fire authority before passing the plans?
Correct.
And the 2005 order applied to parts of Grenfell Tower, didn't it?
Yes.
So that meant RBKC had to consult the London Fire and Emergency Planning Authority as the relevant fire authority. Is that correct?
Correct.
And we know, as a matter of fact, RBKC did do that on two occasions, first on the 11th of November 2014 and again later in February 2016. That's right, isn't it?
Yes.
Now, in terms of that first consultation, The inquiry, RBKC and the London Fire Brigade have been unable to locate the substantive response from the London Fire and Emergency Planning Authority, and you record that at paragraph 298 of your report on page 96. So we don't know what the substantive response was.
No.
But I just want to ask you a few things about that consultation and what it did and didn't comprise. Is it correct that the role of the Fire Authority was advisory, so it had no power itself to reject the plans or impose conditions?
Correct.
And in terms of the scope of the consultation, if we just look at what you've said at paragraph 466 on page 139, that's right at the bottom of that page, you say, in my experience, for all but high risk, very high rise or complex projects, and where no dispensation of the building regulations relating to fire was proposed, the consultation expected by both the building control body and the fire authority related to B1 and B5 matters only. Do you see that there?
Yes.
Now, in your view, was Grenfell Tower a high risk, very high rise or complex project?
In my experience, not high risk. On the basis, if it complied, it would have not been high risk.
A very high rise or complex project?
It's high rise, and it's not. I wouldn't say it was complex.
Right. The words you've used in that, perhaps we can go back and look at the bottom of that page, I think is very high rise. In my experience, for all but high risk, very high rise. Do you see that there?
Yeah.
And can you help us? What do you mean by very high rise projects?
At the time, I would have thought of something like 50 or 60 metres high.
Right.
Now it would be over 30 metres or over 18 now.
I think Grenfell was around 62 metres high.
Is it?
So does that mean that Grenfell 67, Mr. Millett is correcting me?
On the basis it was an existing building, I wouldn't have. It's not something I would have thought on the basis of what was proposed would have gone to the fire brigade, fire engineering department, who dealt with the higher risk type buildings.
I see, yeah. Now, have you had the opportunity before giving evidence today to review the second witness statement of Lindsay Seal of the LFB?
Yes, I have.
Yes. If we can bring that up, this is LFB 2011189998. LFB 2011189998. There? It's not coming up. Okay, can we check that? Okay, we'll check that. Perhaps what I can do is just explain to you while we find that what she says in her witness statement. I know you've read it already. And she says, inspecting officers are more likely to offer observations in relation to the building regulations in terms of means of warning and escape, B1, and access and facilities for the fire service, B5. And then she says, this does not amount to restriction or limitation on what inspecting officers should and should not do. And if there are other critical issues apparent in the consultation documentation provided, then it would be illogical for such issues to be ignored. Now, just pausing there, do you agree with that although they're more likely to offer observations on B1 and B5, that's not a restriction or limitation on what inspecting officers should and do consider if there are other critical issues apparent in the consultation?
Yes, because they can comment on whatever they like, really, in relation to fire safety, yes.
Yeah. And then she says, however, an inspecting officer can only consider and consult upon the information provided and within the bounds of their competence. It's not the role of that officer to second guess or peer review compliance decisions made by the building control body. Do you agree with that?
I do.
So I was just reading for the transcript. That is paragraph 11 on page 5. And then at paragraph 12, she says, matters relating to means of escape and firefighting access facilities are the main areas on which the experience and knowledge of inspecting officers can be brought to bear in their consideration of simple and standard consultations, hence the focus on them. Again, do you agree that that's the reason why they often focus on B1 and B5?
Yes.
And then at paragraph 23 on page 9, she says this. She said, I would not expect our locally based inspecting officers to offer any specific observations in relation to the building regulations beyond anything they've noted from their review of the consultation relating to general means of escape and firefighting access facilities. Now, pausing there, would you agree with that? That you wouldn't expect the locally based fire officers to offer any specific observations beyond anything they've noted from their review relating to means of escape B1 and firefighting access B5?
That would be the norm, yes.
But then she says this, any comment upon B2 to B4 was and is more likely to be made by the fire engineering group following an internal referral, although, as I explained below, such comment, particularly in relation to the external wall construction, was unusual. And again, does that accord with your experience that any comments that you might get from the fire authority on B2 to B4 were more likely to be made by their fire engineering group? Is that right?
Yes, that's correct.
And would you agree with her that, particularly in relation to external wall construction, such comment was unusual?
Yes.
And then at paragraph 46 on page 16, she says, in terms of external fire spread, B4, the Exova strategy issue 3 that was provided with the first consultation detailed that, and then she sets out a quote from that Exova fire strategy, and it's the quote we're familiar with. I'm going to read it now. It is considered that the proposed changes will have no adverse effect on the building in relation to external fire spread, but this will be confirmed by an analysis in a future issue of the report. So she records that there. And she says this, she says, due to this statement and there being nothing in relation to B4 highlighted by the building control body within either consultation with us, there would be no reason to comment or question this area of the design. The expectation would therefore be that, unless otherwise advised, the design would comply with the building regulations in this regard. Do you see that there? So what she's saying is the combination of the statement that was made in the Exova fire strategy, that the proposed changes will have no adverse effect, but will be considered in a future issue, together with the fact that there was nothing in relation to B4 highlighted to them as the fire authority, meant that they would have no reason to comment on that area of the design.
I agree.
Now, do you agree with that?
I do.
But in your opinion, should the building control officer on Grenfell Tower have highlighted to the fire authority that there was a lack of information about the cladding proposals and compliance with B4 at the time of considering the full plans application? Should that have been communicated to the fire authority?
I don't think there would have been anything to gain from those comments. And I think, as I've said in my report, I don't think the application should have been accepted to start with, or because the building control body had categorically stated that they couldn't say it was acceptable to them. I don't think it should have gone on in the initial stage to the fire brigade.
Yeah. So you're saying it was so inadequate that actually it shouldn't have been sent to the fire authority for consultation at all at that stage?
Even on the basis of B1, because what was said to be proposed and supported by the fire strategy was not in fact what was shown on the plans to be built.
Yes, I understand. Now, just on this topic of consultation, but different kind of consultation now, are you yourself aware of any requirement to consult residents as part of considering a building control application where it involves renovation of an existing occupied building?
To consult them, no.
So you're not aware of any requirement to do that kind of resident consultation?
No.
Now, in terms of your compliance assessment overall, I just want to ask you a few general questions about Mr. Hoban's approach to checking compliance with the building regulations. We now know that he says he gleaned some evidence from site, from knowledge from site. For example, he says that he saw the insulation and the ACM on site. And then he says he went away to check for further information. Now, again, subject to the caveat that that factual evidence will have to be considered by the panel. But if we take that as our starting point and assume that's right for the present purposes, would that be a common way of doing things in the industry? For example, to get information from site and then go away to check other information relating to what you've seen on site?
I would say it is often done. It usually triggers a contact to the applicant to say, I have seen on site XYZ, I need details of it and justification for your using it.
Yeah. Yeah. So you put the onus back on them to justify to you what you've seen or been told on site.
Yeah. You might go away, look it up and have an idea in your mind from the details provided, but then when those details came in, you could then sort of compare what you knew about it to what was being proposed as given as the detail.
Yeah. And just to be clear, I think what you've said is there needs to be a very clear written record of what you've seen on site and what further information you're requiring. Is that correct?
Yes, for lots of reasons, yeah.
Yeah. Now, we also know that Mr. Hoban said in his oral evidence that he trusted Studio E and believed that they knew what they were doing, and he thought it reasonable to expect that they would know and understand the building regulations. That was his evidence at day 45, page 202, line 23 to 203, line 25. In your opinion, is it ever reasonable for a building control officer to make assumptions about the level of skill and competence of an architect or a builder?
Not to make assumptions, no. That's the American way where the plumber or whoever writes an affidavit, signs an affidavit that it complies. But that's not the way we do it in this country, no.
And you wouldn't ever assume, perhaps based on, I mean, what he said is that he'd worked with them previously on the Calc project. If you've worked with someone previously and you think they've done a decent job, would that perhaps reasonably lead you into assuming that they knew what they were doing and perhaps that you didn't need to check everything as thoroughly as you otherwise would?
No, because the academy was a school, wasn't high-rise, and the Grenfell Tower was a high-rise residential block, completely different.
Yeah. Does the fact that a fire engineer had been engaged on the project and provided some advice, does that affect the level of scrutiny that a building control officer should exercise on a project?
No, it just, if they're a competent engineer, it makes your job easier because the justification and the information is usually set out for you.
Was it reasonable for Mr. Hoban to assume that compliance had already been checked by the design team?
He may have assumed it, but he didn't have any evidence of it.
And therefore, in your view, it wasn't reasonable?
Was not reasonable.
Yeah. Do you agree that the task of building control is made markedly more difficult if members of the professional team don't work collaboratively with it? Don't attempt to make its task easier and don't inform it if they identify themselves areas of non-compliance or potential non-compliance?
Yes.
Have you seen any evidence of that kind of behaviour on the Grenfell project from what you've reviewed?
I can't say that I have, but there has been no request from building control for that. So it may be, I can only surmise that because they weren't asked, they assumed that it wasn't required, but that was wrong.
Yeah. Now, we've heard from Mr. Hoban that he says he was given various verbal assurances on site about the compliance of the cladding. If we can just look at your report, paragraph 42, page 11. you say this, you say Mr. Hoban appears to have relied on the unsubstantiated word of the contractors that the cladding achieved Class 0 classification for the fire surface spread of flame and met the criteria within ADB for cladding incorporating combustible materials for a building exceeding 18 metres in height. This was a fundamental failing on the part of the building control body. So we have that there. Has anything you've heard in the oral evidence changed your view in any way about that?
No.
Now, we've been through your evidence of the failings that you've identified in RBKC's scrutiny of the refurbishment project. You've heard the oral evidence of Mr. Hoban and Mr. Allen and the reasons they gave for why they didn't do things, and he now accepts, in some occasions, with hindsight, things ought to have been done. Do you have any further comment you want to make in relation to that evidence as relevant to your conclusions in your report?
I don't believe so. Having heard the evidence of Mr. Hoban and subsequently had sight of the HR records, I feel he was struggling. He appears to, and in the joint meetings between the two gentlemen, it was stated and recorded that he was at one stage 50% behind on his site record keeping. And yet during that time, as that figure was going up, he was asked to take on and did accept 2 additional patches into his overall control, which seems a bad management decision as regards getting the best out of a building control officer.
Yeah. Now, having heard evidence about the size of the building control department and the number of projects that Mr. Hoban was overseeing, are you able to give us your opinion on whether the building control department, in your view, appeared to be overstretched at the time of the Grenfell project?
The department as a whole, I can't say Mr. Hoban appeared to be, but having said that, without details of all the other jobs, whether they were dormant, the size of them, etc., I can't categorically say he was overburdened.
Yeah. And I think the chairman's already asked you this morning about the number of projects that Mr. Hoban was working at a given time. I think he said at its highest it was 120 to 130 projects, and you've already provided some comment on that this morning. Do you have anything else to say about that?
No.
Now, quality control now is a separate topic. Now, is it right that you found no evidence of RBKC having a quality control policy or document management system?
That's true. It's mentioned several times in documents, but I've found no evidence of it.
Yeah, and I think you explain that in the building control performance standards that were in force at the time, it was left to a local authority to create a business policy to enable maximum effectiveness in achieving compliance and formulate its own documented quality control management system. Is that right?
Correct. Some building control bodies go for British Standard quality control attainment, which is reviewed occasionally, but not all.
Yeah, and I think just in terms of the transcript, the reference for those those performance standards are INQ 303-13959 and CLG 100006814. Now, you've also said in your report, this is at paragraph 33 in your summary at the beginning on page 9, that you've not seen evidence of a quality control system or quality audits being undertaken by RBKC. Is that right?
Correct.
Can you just help us as to what you mean by a quality control system and quality audits?
Monitoring by management that the work being produced by their officers was as required and fulfilling the requirements, procedural requirements and technical requirements of the building regulations.
And what kind of quality audits would you have expected in a competent building control department?
Checking that decisions were being made within their time limits, checking that all aspects that were necessary were being achieved on the jobs by randomly perhaps picking out a job and basically peer reviewing it.
Yeah.
Or sitting down with your junior members and going through their jobs to make sure that they were actually doing what was required, and making sure that where completion certificates were required, they were actually being issued and issued on time and issued correctly.
Yeah. Now, you've talked about peer review there in the context of a quality audit. In your view, would it ever be the case that a building control department would have more formal peer reviews of work on projects to check that they were being done correctly, or a second check? Would that ever happen? Was that common?
Not a technical check that I know of being common. It would be if you were going for ISO registration, that they would be looking at your processes and your documents to see if you had documents that were giving the information to that was available to everybody, as in who needed it.
Yeah.
But no, it may be, but I can't give any detail that perhaps an authority would ask another authority to come in and review, but I can't give any examples of that.
In practice, how would you expect building control bodies to ensure that quality was maintained in the work of that department?
I would expect the manager to have processes in place whereby there was periodic review of what actually was taking place within the department and the quality of the response to the applications.
And to what extent would you expect there to be a system for line managers to check the work of those working beneath them?
There should be sort of an appraisal, if you like, definitely annually from the point of view of the employment. Also, they're keeping up with technical information. And generously just reviewing to make sure they weren't being overburdened and were doing what's expected of them at that level.
Would that ever be as specific as checking on physical inspections that had been done on site, or checking test certificates and that they'd been looked at? Would you ever take it to that level in terms of quality control?
Yes, I think so. I mean, it was not uncommon for the head building control officer to arrive on sites unannounced to check that his men had been there and had done what was supposed to have been done.
Yeah. Do you agree that there is no specific requirement for a local authority building control body to have in place a quality control system?
I believe that's so.
Yeah. Now, site visits. I want to ask you about the site visits carried out at Grenfell Tower. In paragraph 125 of your report on page 36, you state that there's no generally available guidance as to how many inspections should be undertaken. Is that correct?
In as much as there's no minimum, a local authority building control body is not required to inspect, but as an offence can only occur on site,
Yeah.
that's the only means of checking that the regulations are being complied with.
Yeah.
So you would, there's guidance in the latest draft of the BCP SAG and documents as to the number of inspections, but it's all based on the complexity, the knowledge of the builder, whether they are competent, etc. So it is a judgment, but once it's set out, it doesn't mean that you can't do 10 more or 10 less.
Yeah. I think it follows from what you've just said that you would agree that it's difficult to be too prescriptive and specific about the number or frequency of inspections, given the multitude of different building project scenarios a building control officer might deal with.
It is. The recommendation, again, it's informal recommendation, is that you should visit the site, a dormant site, periodically to ensure that it is still dormant.
Yes.
etc.
Yeah. Now, you've helpfully referred to those building control performance standards. We know that the 2017 version of those, that's CLG 5042 at page 27, we don't need to go to it, they say that the scope and frequency of inspections should be determined and incorporated in a formal written plan. But then this was a change, I think, from the 2014 guidance, which we can see if we bring this up. This is CLG 1006814, page 16, under the heading Inspection Frequency. In the middle of that page, you can see there's a heading Inspection Frequency, and it says there, the scope and frequency of inspections should be determined and incorporated in a formal written plan. Plans should be kept under review as the project proceeds. And then in the next paragraph, all sites should be inspected frequently. This is unlikely to be less than one visit every 28 days for all live and reasonably active sites, and 3 months maximum for non-active sites to ensure that legal control is maintained. Do you see that there?
Yes.
And was that kind of frequency common practice within the industry? So it's saying they're unlikely to be less than one visit every 28 days for all live and reasonably active sites. Would you agree with that, that was common practice?
Yes. Generally, yes.
Now, Mr. Hoban's evidence was that he endeavoured to visit site once a month. That's RBK 3050416, page 19, in his second statement at paragraph 48. In your opinion, was that reasonable to endeavour to visit site once per month?
I would say that was a minimum, but when visiting, it should be established what was likely to come before the next visit, and it may be that you'd have to cover the next day because there was something that was going to be covered up. So you needed to adopt a flexible approach to it. What I would say is the site visits anticipated was probably reflected in the fee, because the fees are separate. But
I see.
It's a case of a visit will likely dictate when you come back the next time. What I did find strange in Mr. Hoban's evidence was that he said it was not a site you could just turn up to. Well, I appreciate if you go to a site, you can't just wander all over it for health and safety reasons. But I find it a little strange that he would be dictated to as and when he could, in fact, go onto the site.
Right. That wouldn't be normal in your experience.
I don't think anybody would, well, unless they had something to hide, shall we say, anybody would refuse a building control officer access to a site, unless it was particularly dangerous at that time to do so.
Yeah. Now, having heard the evidence and considered the documents that have been disclosed, and in particular the revised chronology from RBKC, would you agree that Mr. Hoban generally did manage to visit site once a month?
I think there are a couple of periods when it was longer than a month. But it may have been when he was ill.
Right.
I did notice in his HR or the appraisal notes is that they found it difficult to cover when he was off sick because they couldn't find the files or his notes.
Yeah. Overall, what is your opinion on whether the number of inspections was appropriate for the project?
I think at the time when the site was running as they had hoped it would run, if it was just repeat after repeat, it's difficult to say, but if he was there at least once a month, that was probably anticipated as being acceptable, but in retrospect, knowing what he didn't look at, probably not.
Okay. Do you agree it would be good practice for a building control officer to arrange visits with a contractor so as to ensure that they visit when there is something to see that needs to be inspected?
That would not be the only time. That would be definitely a time to visit, but there would be additional visits, no doubt.
Right. Would past experience of a contractor ever be a relevant factor in determining the frequency of inspections?
I believe it would, yes.
Now, RBKC accepts that the site visit notes were not sufficiently detailed. However, do you agree that it would not have been normal practice at the time for local authority building control services to compile a detailed report of each site visit?
I don't think poor notes is common practice. It's the only method of recording that you've actually done your job.
So would you have said at the time that it was common for building control services to compile detailed reports of each site visit?
Depends what you mean by a report. There would be notes of what you had seen,
Yeah.
what you found was not acceptable, and the action that you took at the time to get that put right.
Yeah.
But not a full report. There just wouldn't be time, probably, to do that.
Now, if we go to paragraph 528 of your report on page 152, you've helpfully indicated there in a list of what records of site inspections should have indicated. And then below that, at paragraph 529, you've said the recorded notes do not contain sufficient detail. Do you see that there?
Yes.
Now, is that something that those supervising Mr. Hoban's work ought to have picked up on at the time, that the site visits notes he was recording on Accolade or elsewhere were not sufficiently detailed?
Yes, I believe that should have been picked up. Having said that, I don't know what the general level of detail was at RBKC. I've got no knowledge of other projects.
Okay. Now, Regulation 38 now, I'm on to my last three topics, one of which is very short. We've heard evidence from Mr. Hoban that it was RBKC's practice to accept a verbal assurance that Regulation 38 had been complied with, i.e. the handing over of fire safety information to the responsible person by those carrying out the works. That's day 46, page 201, lines 19 to 23. Mr. Allen also gave evidence that this was his practice, day 47, page 190, lines 2 to 14. Now, is it right that you are aware of this practice in other building control bodies as well, i.e. accepting a verbal assurance of compliance with Regulation 38?
Yes.
Is it your view that this was an acceptable approach for a building control body to take?
At the time, yes, provided it was recorded that they had accepted that as being adequate, as being the indication that it had been passed over.
I see. So you're saying it was okay to accept the verbal assurance, but that verbal assurance needed to be documented.
Yes.
Can you help us as to how that fits with the requirement of the regulations to take, quotes, all reasonable steps to satisfy themselves that it complies with the relevant provisions, including Regulation 38, before issuing any completion certificate under Regulation 17?
The Regulation 38 requires that the person carrying out the works passes over that documentation. In hindsight, it's proven to be an inadequate method of satisfying oneself that that is adequate, verbal is adequate. But the onus was on the person carrying out the work to pass that information over. The responsibility of the building control body was to obtain information that had been passed, the information had been passed over.
I see.
The level of that information would have been determined by what the building control body thought was adequate in the circumstances, or what they should have attained.
Does that mean, do you think the building control body would have had any role in checking the information provided to see if it did in fact satisfy Regulation 38?
As best practice, yes.
Does you referring to best practice means that you wouldn't think it fell below reasonable standards at the time not to check?
It was the way of complying with Regulation 38 at the time varied. As I say, some would take a verbal confirmation, others would have a slip at the bottom of the building regulations application form that people would sign and tear off and send back as confirmation the information had been passed over. I honestly cannot recall anybody who has received all the documents and checked that they were adequate for the purpose.
I see. So does it follow then that you don't think a reasonably competent building control body needed to receive all the documents and check them?
That would have been my view at the time. Yes.
Your view now, looking back on it, was that an adequate way of dealing with Regulation 38? Just to have it in a slip?
No, there should have been some evidence as to what had gone. I've subsequently asked building control bodies what evidence they require as to compliance with Regulation 38, and they have said variously a copy of the O&M manual, the Operation and Maintenance Manual, or lists of the documents. It would, on some projects, the O&M manual, which contains this information generally, can be 6, 8 or 10 volumes.
Yeah. And sitting here now, do you think reasonably competent building control bodies, if provided with the O&M manual, should do at least some check of that to check that it contains the right information to be handed over?
Yes, I think it would be good practice in asking for that evidence, that the evidence is extracted from the O&M manual rather than them having to plough through how to clean the toilets and everything else and the carpets that goes into an O&M manual.
Yeah. Now, you've given your view in your report on the options for who the person carrying out the work is under
Yes.
Regulation 38, and ultimately that's a legal issue for
Yes.
the panel to decide. To summarise your view, you say the building owner can be the person carrying out the works because they're the ones who decide whether to carry out building work, and that the overall aim of ensuring a building has a reasonable standard of safety is to take effective action, i.e. to enforce against the person capable of correcting deficiencies. So those 2 points lead to your view, I think, that you think the person carrying out the works is normally the building owner, is that right?
Yes.
But you're also aware of a contrary view that the contractor is the person carrying out the work. Would you accept the proposition that because Regulation 38 requires the provision of information about building works, the party best placed to provide that to the responsible person is the contractor, because they're the ones with intimate knowledge of the works?
Yes.
This is really sidling up to a question of construction of the regulations, isn't it?
It is, but I'm interested in this witness's understanding of the regulation. And ultimately, I've made it clear it's a matter for the panel.
As a building control officer, I don't think it matters where the information particularly comes from, but it should be accompanied by a statement the person carrying out the works is aware that that's gone over to the responsible person under the order. If it's the building owner, they won't have that information. They would have to get it from their agents, whoever's responsible for compiling that on their behalf and pulling that together.
Yeah. Do you agree that if the TMO was both the person carrying out the work and the responsible person, and that will be a question of law to determine, that do you agree in those circumstances, is it your opinion that there would be no need for formal notification for the purposes of Regulation 38 because effectively it's going within the same body?
No. the building control body needs to be satisfied that information has been passed over.
Yeah.
If it's just passing it from one desk to the other, that may be the practical, physical aspect, but it should be shown that it's been compiled and given to the people who are going to operate the building.
Yeah. So you wouldn't just accept that it was going within an organisation. Your practice at the time would it have been to check and ask whether it has been formally handed over?
By acceptance of that verbally, yes, it had been handed over, yes.
Now, you referred to RBKC's failure to check that the fire safety information had been provided as a procedural failure and a lack of rigour in their processes. That's at paragraph 494 on page 145. Can you just explain what you mean by a procedural failure?
I can find nothing in the documents that I've seen that the question was asked or written confirmation was sought that the information had been passed over to the responsible person.
Yeah.
I've seen no process whereby that information was required as part of the procedure within RBKC building control.
Yeah. Now, finally, on this topic, just to confirm, we know that you have not yourself undertaken a detailed review of the O&M manual, but Dr. Lane has. Mm-hmm. Do you defer to Dr. Lane's analysis of the O&M manual in terms of compliance with Regulation 38?
I must confess I've not looked at that particular part of her report in detail, but I'm sure she's covered it.
Okay. Now, record keeping, this is my penultimate topic. We know that RBKC has accepted that there were shortcomings in aspects of the record keeping on this project. Can you just give us your overall opinion about the standard of record keeping for the Grenfell Tower project?
From what I've seen, it was inadequate to allow any third party who was reviewing the project to ascertain whether compliance had been achieved.
In your view, was there a failure to comply with the standards contained in the Building Control Performance Standards 2006 and 2014 in regards to record keeping?
Yes.
Would a competent building control body have had in place a policy requiring each building control body to identify the means by which compliance was being achieved and recording what evidence substantiation the person had seen that compliance by such a route was being achieved?
I would hope so. It's the only means by which they can be shown to have been carrying out their duty.
Yeah. Do you accept that it would have been normal practice at the time for local authority building control services to weed their files at the end of projects, I filter out material and dispose of material, rather than keeping the whole file, provided that sufficient documentation was retained to enable a reader to identify the key decisions?
Weeding is common practice and it's done for all sorts of reasons, but you have to be careful and have to know what you're doing when you're weeding. From what I've seen, the policy at RBKC as stated by the officers, it was effectively weeding down to the point where everything went, which is obviously no good in looking back or having any records of what's gone before, which allows you to determine if you're making it worse by the next proposal.
Yeah. Now, finally, I just want to go to your overall conclusion about the completion certificate. Can we go to paragraph 47 of your report on page 11? Now, there you say that a completion certificate should only be issued by a building control body if it is satisfied that the fire safety information required by Regulation 38 has been given to the person defined as the responsible person. And you say this in the last sentence, in the absence of evidence that Regulation 38 had been complied with, I can only determine that a completion certificate should not have been issued. Now, does that remain your view?
Yes.
And is it also your opinion that a completion certificate should not have been issued because the works did not comply with the building regulations, including B4?
When the certificate was issued, I can only assume that the officers concerned were of the opinion that it did comply, the works did comply.
But is it your evidence that, in fact, the works didn't comply and the certificate shouldn't have been issued?
following the fire, everything I've seen indicates that the building did not comply.
Yeah. Mr. Chairman, I've come to the end of my questions.
Yes.
I'm
very
sorry
good.
that I've taken till 4:30 to do that.
All right. Don't worry.
This is an important expert for the inquiry.
Anyway, we better have a bit of a break now.
Yes, I think let's take 10 minutes.
Yes.
That should be sufficient.
Well, you can let me know if it isn't.
Thank you.
Yes. Well, Ms. Menzies, yes, we're going to have a short break in case something else comes to mind or somebody else's mind as to questions that should be asked. So, yeah, 20 to 5, please.
Thank you.
And no talking to anyone. Thank you very much. Right, well, you can let us know if you
Thank you.
need more time.
Yes, thanks.
Thank you. Yes, would you ask Ms Menzies to come back in, please? Right, well, we'll see if there are any more questions. Yes, Ms Grange, are there any more questions?
Just on one very short topic, which is about photographs.
Yes.
Would it have been common practice at the time for building control officers to take photographs on site and then retain those as part of the record of what they'd seen?
Yes. Yes, it would.
Yes.
Yes.
Does it follow from that you're surprised that there are no photographs in any of the records that we've seen? I mean, I know we don't have the full records, unfortunately, but would you have expected to see some photographs taken on site by relevant building control officers that form part of the documentary record for a project like this?
Yes, it was and is common practice. To be quite blunt, it saves writing a lot of notes.
Yeah.
But it would have been quite common, yes, particularly for key points, yes.
Yeah. Thank you. Mr Chairman, those are all of my
It is.
questions. It just goes to say, and I know you'll say it as well, just to thank Ms Menzies for
Pleasure.
all the incredible hard work that's gone into the report, and thank her very much for taking the time to come and give evidence today. We really appreciate it.
Pleasure, thank you.
Yes. Well, I certainly endorse all that. It's been a pleasure to listen to your evidence today and very helpful to do so. But I know a great deal of work's gone on before you came into the hearing room this afternoon, and we're all very grateful for your efforts and for your
Thank you.
support. So thank you very much indeed. And now you're free to go.
Thank you.
Thank you very much.
Thank you.
Yes, well, that's it for the day then.
Yes, thank you. And we have another expert
We have
tomorrow. We have Dr Lane.
Yes,
Thank you.
good. Well, thank you very much. That's it for today. We'll resume at 10 o'clock tomorrow.
Thank you.
Thank you very much.